Now we're going to get down to the nitty-gritty of what Indians are all about.
I still say we Indian people are believers in the truth. This is the way of life that was given to your people. You're born an Indian, you're going to die an Indian. Indianness is a good life. You're facing an Indian this afternoon.
Good Saturday afternoon out there, everyone, and welcome to your number one source for Native American television news. It's Muskogee Vision. I'm your host, Jason Salzman, here in the Muskogee Media Studios, ready for this week's episode. Lots of great things going on out there as we wind down the summer. You know, lots of things been happening, and we've had a really great summer around here. Of course, covering the big event, the festival, lots of other events, and there's a lot of other things happening around Muskogee Creek Nation to get excited about in the next couple of weeks. Some back-to-school events that are going to be going on. Check your local calendars out there. Make sure that you're aware of all of these events because a lot of the times they have information on these for school supplies, free haircuts, things of that nature, things that go on in the city of Okmulgee that the Creek Nation, which is our capital city, the Creek Nation is partnering with. So definitely keep your eye on all the calendars, the happenings out there, and we'll do our best here on the show and MuskogeeMedia.com. And while I've got your attention for a minute on MuskogeeMedia.com, make sure and go on our shop, into our shop on MuskogeeMedia.com. You can check out all the stuff that we have available, t-shirts, merchandise, stickers, all kinds of things about Muskogee Media, and really it's a way to sort of show your Muskogee Creek pride too, and let everybody know where you get your news, and we have some great designs up there too, so go check it out if you get a chance, MuskogeeMedia.com/shop. Well, let's get down to business of what we do here at Muskogee Vision, and that's tell the biggest news happenings and news stories going on at Muskogee Creek Nation. And right now, it is a lawsuit that has been filed against the Department of the Interior, its secretary, and our principal chief, James Floyd, from the Freedman Band of Muskogee Creek descendants. They recently had a press conference in Tulsa at the Greenwood Cultural Center, and we were there to get their comments.
We are excited and honored to have this opportunity to represent these so-called Creek Freedmen in our quest. And I say our quest because I'm designated as a Creek Freedman myself, erroneously. Our quest for citizenship, full citizenship within the Creek Nation. The Creek Nation in the old country in the southeastern United States of America was a confederacy of nations and tribes and people. And within that confederacy included people that you would consider to be black or Creeks of African descent. In the 1830s, when we were removed from our traditional homeland here to Oklahoma Territory, or Indian Territory, which we now know as Oklahoma, on that trail of tears, so to speak, that also included Creeks of African descent, some enslaved, many free, and also what we would consider to be free blacks or free Africans. They came to the Creek Nation in the territory. They were here, they were productive citizens up until the Civil War. The Civil War split the nation. You had some Creeks who sided with the Confederacy, called the Southern Creeks. You had other Creeks who were what we call loyal Creeks, which included many of the Creeks of African descent. At the end of the Civil War and the treaties were being negotiated, there were 5 individuals who participated in those negotiations and signed that treaty in 1866. One of those individuals was a Creek of African descent, or African Creek, by the name of Cal Thomas, who was my 4-time great-grandfather. He signed that treaty, and in that treaty, you have a copy of it, all our media members and anyone else that wants a copy, will give it to you. Article 2 of that treaty simply says, or clearly says, that Creeks of African descent shall have and enjoy all the rights and privileges of native citizens, including the equal interest in the soil and national funds, and the laws of said nation shall be equally binding upon them and give equal protection on all such persons and all others whatsoever of race or color. That is where we are today. Because from 1866 until the Dawes Commission arose, which first started with the Dawes Act, which was passed in 1893, and then when they created, 1887, when they created the Dawes Commission in 1893, and then in 1898, the Curtis Act, where they forcefully enrolled Creek citizens. It was the United States government that segregated Creek, so-called Creek freedmen. It was the United States government that used the hypo-descent rule that said 1 drop of black blood makes you black. It was the United States government that created a separate role of so-called Creeks by blood and so-called Creek freedmen. That was not something that the Creeks did themselves. However, in 1979, the Creek Nation, relying upon this openly racist Dawes rolls, decided to segregate, strip, and steal the heritage, culture, and citizenship of those Creek, so-called Creek freedmen and their descendants. They are Creek people, period, point blank. The treaty says so, but more importantly, our history says so. Our culture says so. Our birthright says so. So in this lawsuit, we will utilize the Treaty of 1866, the clear language, to get the citizenship that has been denied for almost 40 years, illegally denied for almost 40 years. We will utilize and be inspired by what the Seminole Nation freedmen have been able to do, and the Cherokee freedmen last year, on August 30th, 2017, when they won their successful fight, the Cherokee Nation. We believe strongly that we will win our fight here in the Creek Nation. This is a historic day. I'm proud and blessed to stand here with my clients, my family, my people, to stand up the same way so many Creek so-called freedmen stood up. People like Warrior Renty, and Judge Reed, Silas Jefferson, and Kyle Tom, and Jake Simmons Jr., and the list goes on and on and on.
We're seeking specifically to make sure that they're granted full citizenship, the right to vote, the right to hold office, the right to run for office, the right for all benefits that are granted to all equally situated Creek citizens. We can't accept anything less. That's what we're asking them for. We also have federal defendants in this case. The reason we have federal defendants is because we have to make sure that on both sides of the aisle here, both at the tribal level and at the federal government level, that rights are protected. And we're asking that the federal defendants be enjoined, be restricted from taking any action or providing any benefits to the tribe until this citizenship is granted in full to our clients. In addition, we're asking that the court appoint to the BIA a trustee to make sure that these rights are protected. And that's a kind of a broad overview, but most importantly, what we're asking for is the equal rights for our clients and for the citizens, the Creek freedmen descendants, to be treated as full and complete citizens of the Creek Nation.
We understand that we have a lot of work in front of us, but to have this day is truly historic. It's something that I have personally been dreaming about for decades, honestly. Ever since I tried myself to get enrolled in the Creek Nation in the mid-90s, or the late 1997, and was denied, and had to have that conversation with my grandmother and said, wait a minute, I thought we were Creek. And she explained this to me. Ever since then, I've been waiting on this day. And in the mid-2000s, I got to represent a couple of Creek so-called freedmen in the Creek Nation court system. And we actually had a favorable outcome by Judge Moore, but then it went to the Creek Nation Supreme Court and they kicked us out of court. And so I've just been waiting for the right opportunity, the right time, have the right team to bring this forward. And for this to happen today is tremendous. I mean, a couple of days ago, we filed last week actually, and it was just 152 years after the ratification of the Treaty of 1866. So it's a wonderful feeling to be here with so many of my family members, friends and supporters, and my awesome law firm and law partners and our team. So I'm so excited, very excited.
I was able to film an interview with Chief Floyd, who's mentioned as a defendant in the suit yesterday, and I asked him about the suit, and his response was that he hasn't read it yet. Okay. To your knowledge, has he been served?
To my knowledge, I am not, if he has been served yet, but it's en route if he has not received it. But if he needs a copy, I'm happy to email it right to him so he can have opportunity to review it. I want him to review it. I invite him and anyone else of goodwill who believes in justice, who believes in the law, to take a look at our complaint. And I think anyone in goodwill will say, this is the right thing to do. We shouldn't have a big fight about this, but if we have to, we're prepared. I believe that we went through a 3-year process in the Creek Nation court system from 2004 to 2007. We had a 6 or 7 day trial. We put on dozens of witnesses. We put on hundreds of exhibits. We proved our case very clearly in the Creek Nation trial, saying, Creek, you do what's right, not only by the law, by the treaty, and by United States law, but by Creek ways. Creek people, we try to do the right thing, and we gave the Creek Nation that opportunity, and unfortunately the Creek Nation demurred and forced the hand to have to file in federal court. The Creek Treaty of 1866 is the supreme law of the land, and that's what we put hold on to. We are not concerned with what individuals may believe. We know our heritage, we know our culture, we know our birthright, we know who we are. I will go personally toe-to-toe with any Creek citizen and go back through my lineage, which I can go all the way back to the old country and bring it all the way forward with Cal Tom signing the Creek Treaty of 1866, with Legacy Perryman being a family member of mine, with Moses Perryman, and the list goes on and on and on. But I don't have to do that, because all I have to do is point to that phrase in Article 2 of the Creek Treaty of 1866 that says Creeks of African descent are guaranteed citizenship just like any other Creek member, and that is the law today.
All right, and there you have it, the Freedmen Band and their lawyers representing them. They're explaining the lawsuit in Tulsa. We were invited to that conference, definitely wanted to go to get a piece of that. And also, if you notice at the end of the piece there, we had an interview with the lead counsel, Demario Solomon Simmons, and he referenced an earlier case that he had argued in Creek Nation District Court, received a ruling, was then kicked back from the Supreme Court, but that ruling was presided over by Muskogee Creek Nation District Court Judge Patrick Moore. Now, he's been on the program before, as you know, if you've watched our show, as a resource for us when it comes to Indian law, things like that. Again, he's the longest tenured district judge in Muskogee Creek Nation history, so he's a wonderful resource for that. But because he's presided over that earlier case, we wanted to have him in and talk with him about the case, the differences between this case, and really general information about the issue. In a recent interview we were able to obtain with Demario Solomon Simmons, who's the lead counsel for the Freedmen Band in this recent lawsuit brought up against the Secretary of the Interior, Department of Interior, and Principal Chief James Floyd, he referenced a case previously that he had was able to argue for in the Muskogee Creek Nation District Court in 2003, in which you were the judge on that case. Can you just tell us a little bit about that case that he referenced?
Yes, the case involved Ron Graham, who had been denied citizenship on his applications that were filed 3 or 4 times during the 1990s. His application for citizenship was based on some other laws and ways that you could become a citizen of the Creek Nation that is provided for by the Constitution of the Creek Nation. By the time he filed his lawsuit, those laws had been repealed. However, when I looked at it, I thought that the Citizenship Board administratively should consider what the law was when he filed his application. And that was the end result of the trial that we had, which went over several days. Part of that came from testimony from people that worked and were chairmen and workers in the Citizenship Board of the Creek Nation, where they said they didn't consider those old laws because they weren't trained to consider them. And of course, this was 2003, and those laws that were passed back in the late 1980s were repealed in 2000. So all I did at that time, because I hadn't been ordered to do anything by the Supreme Court, I did have a Supreme Court case on Mrs. Todd that had come down from the Supreme Court after I had ruled in her case, and she was having her citizenship taken away from her after she had already been approved as a citizen. And it's the burden of proof in that case, the Todd case, is on the citizenship board when they've already approved someone. It's not as easy to take away your citizenship as it is to get it in those instances. And in that case, I had remanded it back to the citizenship board for them to review the criteria for their ability to remove the case. That case went to the Supreme Court, and I was upheld on that administrative review. This Graham case went to the Supreme Court after the Citizenship Board, through the Attorney General's office, appealed what I had decided at the lower court to go back and have it administratively reviewed. There actually hadn't been any decision of the court other than to send it back and have the administrative body follow the law as I saw it. It was in place in the 90s when Ron Graham filed his petition. In the Supreme Court sent me down a request for clarification on many items that they weren't at the trial level, and I had to look at the trial transcript to determine what those were, and sent that back to the Supreme Court. The Supreme Court had records and transcripts of sworn testimony where the chairman of the Citizenship Board for the Creek Nation. Now we're in 2003. After that, the law was these laws that they were relying on were repealed in 2000, and the chairman and the people at the election board stated in court that they were told not to pay attention to those rules. Well, my thinking on that was you file for stuff under the law as it is when you file, not when the government changes it later on. However, the Supreme Court did not agree with me, and they ruled that the case they ordered me to dismiss the case. That's what happened, and that's what I did.
So both cases, essentially, if you just go blanket rationalization, are freedmen seeking citizenship. But that's sort of where a lot of the similarities end, because these are very different in certain aspects.
The Graham case that I handled had to do with the statute and its interpretations. The early Creek Nation National Council passed a law that added several different ways you could become a citizen, not just the Dawes Commission. Excuse me. After 2000, the National Council repealed those laws and took them out and went back to what the Constitution says, which you have to be a lineal descendant off of the Dawes Commission rolls. But as I said, my position was somebody applied for their license under the old law, and if they qualify, they should have their license, for instance, or they should have their citizenship. The Supreme Court asked for clarification, which I've told you about, and then they ruled that the old law didn't apply and sent me an order telling me to dismiss the case. When the Supreme Court sends me an order, I follow their orders, and I dismiss the case. Simple as that.
You look at what you've said as far as at the timing of the case previously that you heard, and just a few years prior you said laws were repealed. I would wonder if for the audience that may be watching this interview would hear that and say, well, that could happen again, possibly. What's that process? I mean, how quickly can that happen to change everything about a way the case is decided?
Well, the National Council can change the law anytime they wish, and they could change it back. They can do as they please with the law, assuming it's within their purview and doesn't violate the United States Constitution or some orders of the United States Supreme Court or legislation of the United States Congress.
Again, just to clarify, the National Council can order Citizenship Board to change citizenship requirements?
They can change the way you get citizenship.
Right.
In other words, in 1980, they added some other ways to become citizens, not just off the Dawes Commission rolls.
Right.
And that's what was not considered with Ron Graham's applications that he filed in the 90s. The ruling was made after the law had been changed, and the Citizenship Board did not consider those old laws. I just merely thought that they should consider those old laws, and that's what I ruled. And then when it finally got to the Supreme Court, 5 justices said the new law is what applies, and sent me an order dismissing the case. So I dismissed it.
Another one of the big differences, and I think you pointed this out too, is that whereas this new lawsuit really has a lot to do with the Treaty of 1866, the previous one that you heard had nothing to do with the treaty.
The case that I heard on was Graham's case involved a statute. There's a world of difference between a Creek statute and a treaty of the United States, and they're poles apart. Treaties are the supreme law of the land, and the only way Indian tribes exist today is because they follow treaties. That's how they get their rights. If the treaties were all thrown out, then everybody can just pack their tent and go home, because you won't have any Indian nations left.
You know, not to speculate what the outcome of this newest lawsuit would be, but we have seen precedents from other tribes, specifically 2 very large tribes right in Oklahoma. Can you talk a little bit about what we could maybe learn from those cases that we could almost speculate as to what may happen here or what the possible outcome could be?
Well, the Seminole Nation and the Cherokee Nation have had this settled for them by the federal court system based on their treaties with the United States of America after the Civil War. I think there's going to be a lot of study on particularly between the Creek Nation and the Cherokee Nation treaties to see where the differences are. And therein lies the problem for the Indian tribes. Plus, as I mentioned, treaties are very important. They're the life of these Indian tribes. Without treaties, they don't exist.
As governments.
Correct. They evaporate. And particularly with respect to the Creek Nation, it's involved in 2 treaty matters right now. One of them involving a murder case, and this other one involving a citizenship. And in one of them, they want to uphold the treaty, and the other one they may want to not uphold the treaty, and where's the winner there?
This is, of course, going to the D.C. court. If they rule in favor of the plaintiffs in this case, what does it mean for what happens then at the tribe?
Well, number one, nobody knows what the court's going to do in D.C. We do know that they issued an opinion in the Cherokee case. But I'll not speculate on what the judge will do in D.C., and plus that's a district court. From there, they might want to go to the appellate court, the Second Circuit, which is the mini Supreme Court. So it's not over. It's not over. But it's a different issue than I handled in the case with Ron Graham. Let's
just say, for instance, they do rule in favor. What then happens at Creek Nation? I mean, what is then the move for Muskogee Creek Nation government at that point?
Indian tribes are always in jeopardy when they have to have a court make the decision. And it's been my observation in Supreme Court cases involving Indian tribes, when they hold against the Indian tribe, something bad happens along with it. It's always happened. And that's what you have to avoid. That's all I can say about that, because the big boys in Washington, D.C. make decisions on this stuff. I'm just an old country lawyer.
Is it fair to say that it's, citizenship is it's proving to be a very complex issue because of all the things that arise and how it's changed, and it's been very fluid. What makes you a citizen today may not make you a citizen next year. Mm-hmm. Can you kind of see this constantly being a problem until this is what makes you a citizen, if you have blood lineage, or if this is, is this something that will constantly have to reassess, go back and argue?
Well, actually, the Santa Clara case, federal Supreme Court case, says Indian tribes can determine who their citizens are, period.
Yeah.
And when you're down to a Dawes Commission, and I've talked to people about this for years, the Dawes Commission roles were created by a federal statute. What happens if they repeal that federal statute?
I know Dawes Commission roles.
No roles.
It doesn't make any difference anyway.
So the Indian tribes need to take their own sovereignty, change their own constitutions where we're organized under our own inherent sovereignty. Then you won't have the federal government coming in and say, you aren't one. You see, the Hawaiians are that way. They don't recognize the federal government. But we've been led around by the nose for so long, the Indian tribes think they've got to do everything the feds tell them, and they don't. It took us a while to get the approval of the Bureau of Indian Affairs out of the Creek Nation Constitution. But that was done about the same time as the Graham case was filed. So the Creek Nation's done a lot of things, but they still have reference to federal statutes in their Constitution, which are wrong. There's things in the Constitution that were put in there by the Bureau of Indian Affairs, which the judge in Washington, D.C. said for them not to put in there, but they went ahead and put them in there anyway. The 1866 and 67 Constitution is better than the one we got today. But they didn't want to do it because it's much easier to control a small body rather than a bigger body.
And we want to thank Judge Patrick Moore for coming in and speaking with us on the issue. A lot of things still yet to cover. Don't worry, ladies and gentlemen, as we always do here at Muskogee Media and on Muskogee Vision, we will get all pieces of this story, all parts of this issue. I have scheduled for next week an interview to talk with some Muskogee Creek citizens that want to let everyone know how they feel about the issue. They want everyone to know what their stance is. And then I've also got some other Muskogee Creek citizens that have a different view of the issue. So we're going to have a little piece of everything here for you on Muskogee Media and Muskogee Vision. That's our job, ladies and gentlemen, to get every single part of the story, and we will never stop until we do that. And we will not give you an incomplete story with just one side of anything on here. So we're working to do that. We're getting those interviews together, getting some people together for that, and we'll have it for you next week. So in the meantime, keep checking us out on our YouTube channel. Keep going to MuskogeeMedia.com. For Jared Moore, I'm Jason Salzman. We'll see y'all next time.